This hearing is in the matter of CA 011-2022 before Acting Registrar Ayesha BinKalban. The appellant is represented by DLA Piper Middle East LLP. Lead counsel is Mr. Raj Pillai, KC. The respondent is represented by Dens & Co. and the lead counsel is Mr. James Wheel.
Good morning, everyone. Just to begin with, I just wanted to basically let the parties know sort of what my initial view is. So you don't need to take me through a full background. I'm very familiar with this case from the day it was filed. So you don't need to take me through an extensive background on what has basically happened in this matter. My initial view is I have received the prospective costs sheet filed by the respondents, and I've reviewed the appellant's skeleton argument and what's set out there in response to the amount of prospective costs that are basically been estimated by the respondents. I do believe that they are excessive, and I would like to go through some form of an assessment of those costs. But I'm entirely in your hands as to how you'd like to proceed. So can I assume that Mr. Wheel, you'll be going first?
Yes, that was my assumption on the basis that we're seeking the costs. That's a very helpful initial indication. Could you please also give an indication on your view in relation to the supposed stifling argument? Because you'll have seen that the defendants say that they can't afford to pay more than 65,000. I take it from the fact that you're interested in a detailed breakdown that you're not with them on that, but it would be helpful.
No, I'm not. I don't think that the 65,000 is appropriate. Is an appropriate amount for security. So I would like to. My initial view is I'd like to bring down the headline costs to some extent. So as far as we can get on that, that would be my initial view on how I think things should proceed.
That's understood. That's very helpful.
Madam Registrar, before we get to that, then I think there is one point that I need to ask for your ruling on, probably, which is in relation to the format and the evidence that's before the court about those costs that Mr. Wheel is going to then speak to.
I was going to address you on that, if that helps, because I appreciate my learned friend has taken some technical procedural points on the form of the schedule, but I was going to deal with that as part of an analysis.
I think I do need to hear from Mr. Wheel first before I make a ruling on that.
Okay, I'm quite happy to reply on that. Thank you, ma'am.
I'm grateful. I appreciate you're fully conversant with the fully familiar with the legal principles. There is just one point in light of what you said that I think it would be helpful to draw attention to very briefly. Could I check you've got access to the case lines bundle and that's working as it should? If please we could just look at the case that my learned friend relies on, the Pisanti case, which is at ZZS 75.
Yes.
And if you look at paragraph 88, which I think is the paragraph my learned friend relies on, if you look at subparagraph 1, what's said there that is in approaching the exercise of determining quantum for the purposes of security, the court will not attempt to conduct an exercise similar to a detailed assessment, but will instead approach the evidence as to the amount on a robust basis and applying a broad brush. So what I would caution against is getting too much into the weeds of the detail. At the end of the day, you've got to stand back and consider what the appropriate reduction is. Now, insofar, of course, as there are specific points that my learned friend takes issue with, I'm going to address them. That might lead you to conclude that the reduction should be slightly more or less, depending on how impressed you are by those points. But as I say, it's not really appropriate in the present context to go through a line by line analysis. But I'm certainly not shirking from dealing with the points my learned friend raises. I just thought it'd be helpful to draw that particular point to your attention. So in relation to the quantum, as I've said, there are essentially two limbs to my learned friend's argument. First of all, he takes some technical points about the form of the schedule, and then he takes issue with certain items on the schedule itself. I can deal with the technical points quite quickly. Essentially, the first point is that, and you see this at, have you got my learned friend skeleton argument to hand, or do you want me to give you the reference on case lines?
Yeah. All right, which paragraph?
Paragraph 3. Essentially, the complaint is that we haven't provided evidence in line with RDC 25.99(3). And the short answer to that point is that we are not, in fact, making an application for security for costs. The Court of Appeal has already determined that security should be provided. And this hearing has simply been fixed to determine quantum. We've therefore adopted a proportionate approach in that context and have simply filed a schedule of costs. Now, unfortunately, the correspondence isn't in the bundle, but I understand that it was agreed between the parties that we would provide a schedule of costs. So we've essentially done what the respondent asked us to do. It's difficult to see how the appellant rather, can now complain. Now, another point that's taken is that we haven't signed the schedule of costs. Well, I'm instructed that I can undertake to provide a signed copy of a schedule of costs. Now, that signed copy will have to take account of some minor amendments, which I'm going to address you on shortly. But insofar as the point is simply that we haven't signed it, well, we're happy to. So that deals with that. The final point to make in relation to the appellant's criticisms of our schedule is that it's really somewhat hypocritical when one considers the appellant's own evidence. And you can see that at ZZQ 78 on Z lines. This is Mr. Mehta's 10th witness statement. And he deals with his costs for comparison purposes at paragraph 5. And it's the last 3 lines of that paragraph. What he says is, I confirm to the court that my own lawyers, DLA Piper, have estimated that my entire costs for the appeal proceedings will be in the region of 106,000. Now, there's no breakdown of that at all by reference to incurred or future costs, let alone a schedule. So in my submission, it doesn't lie in the mouths of the appellants to complain about the way in which we've presented our schedule, when all that they've done is provide a single sentence. So with those introductory points, is there anything further that I can assist you on in relation to the technical points? I mean, the fact we are where we are, we've got a schedule that's before the court, which I'm going to address you on. Insofar as there are any procedural deficiencies in it, I've explained how those can be addressed. Is there anything else that concerns you at all that I can assist on?
I think I'd just like to hear from Mr. Pillai on the technical points.
I'm grateful, Madam Registrar. Madam Registrar, there hasn't been an agreement that the claimant or the respondent here, SBM, could provide a schedule that doesn't comply with the rules. I don't know if you have the blue book to hand, Madam Registrar, but the context to what we're talking about here is that there's been permission to appeal conditional upon payment of security of costs. do you have the blue book to hand?
Yeah, I do.
If I could ask you to turn up page 44, page 578, the note at 44.22.3. If you tell me when you're there.
I'm there.
Does the court see there's a heading, permission conditional upon payment of security for costs? And just in that first paragraph, the authors explain that security for costs can be a condition. And then it refers expressly there in the second sentence, however, the general provision in RDC 25.105 deals with the court's power in broad terms that impliedly permit the court to require security in an appeal by reference to the circumstances and conditions set out in 25.1 and 25.102 respectively. So that necessarily, and as it wouldn't come as a surprise, orients us in the conditions at 25.101 and 102. Those are at page 357 of the blue book, Madam Registrar. And the context to considering those conditions at 101 and 102 is a little bit earlier in the rules. So at page 356, Madam, if you see there's a section headed security for costs about 2/3 of the way down the page.
Yeah.
And it says an application for security must be supported by written evidence. Now, it's plain, just pausing to deal with a suggestion Mr. Wheel made, that he said he's not applying for security for costs. Well, he is, because he's applying for an order for the payment of it. Now, the principle, so whether an order should be made or not, has been decided by the Chief Justice, and there's no dispute about that. But then there's a question about the amount. And so therefore, at 25.99, we see that at little 3, the written evidence is to include a statement of costs already incurred, including the information required by RDC 3835 and signed, and the same at 38.4, which is in relation to future costs. So we say that, firstly, there is plainly a requirement in the rules that has to be followed. And as things stand today, deliberately, it appears, because it can't be said that the other side don't know about this rule, and it was raised with them last week in the skeleton argument, they have chosen either to bypass it or ignore it. And we've raised our concern about this already, which is that they're coming to you today, not answering that key question about whether there is some sort of conditional fee arrangement or an actual obligation to pay. And this comes to the heart of it, Madam Registrar, because of course, any order for costs, and so any order for security for costs, must relate to a sum that a client has to pay. And as things stand today, you don't have any confidence or comfort sworn by, as you'd expect, a solicitor or the party itself, to confirm that there actually is a liability in what we say is this incredibly exaggerated sum. And we say it's more than something that can just be washed over, as Mr. Wheel seeks to do. We say it's a prima facie issue that hasn't been addressed. And where does that leave you is that you have to do your best, we say, by reference to the material you have, including the paragraph in my own client's evidence that Mr. Wheel took you to. And the reason why there is no breakdown from Mr. Mehta is that he isn't applying for security for costs. And what he has done is swear to this court what he's going to have to pay. And that reflects the bills and the liabilities that have been set out for his legal representation. So there's no reason for the court to look behind that. So, Madam Registrar, that's my submission on what's tried to be swept away. It would be very odd for this court to make a very large order on the basis of an unsigned spreadsheet, we say. It would be unusual in this court or any other common law court.
Registrar, if I could just come back briefly on a few points. Firstly, I can deal with the CFA point very briefly. I can confirm on instructions that there is no relevant agreement in place that has any bearing on SBM's liability to pay costs for the appeal. So I can deal with that straight away. As I understand it now, well, there are 2 points. First of all, my learned friend took you to the relevant part of the Blue Book in relation to appeals at page 578. What my learned friend wasn't able to point to, because it doesn't exist, is any rule which requires a respondent in an appeal to provide the materials referred to in RDC 25.99. All that he could point to was the guidance written by the authors of the Blue Book, saying that effectively the court applies the same principles by analogy. But that's very different from a requirement that certain evidence be filed. But leaving that to one side, this really is a rather arid debate, because as I understand the way the argument's now put by my learned friend, all that's missing, according to him, is a signed statement of incurred and anticipated future costs. Well, I've already addressed you on that. If all the concern is a missing signature, my solicitors will undertake to provide a signed copy. So this really is a bit of a distraction from what I think you're really interested in, which is getting into the meat of the schedule itself. Now, so far as the absence of a schedule from my learned friend's clients are concerned, the case law, and in particular the Pisanti case, which my learned friend relies on, makes clear that if if appellants fail to provide a schedule of costs, the court may draw inferences that those documents would not support the appellant's position. It might be helpful if we just look at the Pisanti case again. I don't know if you're able to pull it up. This is at ZZS 51.
Sorry, ZZS 51.
Yes, 51. And the relevant paragraph is on page 76 and at 91 Roman 2.
Just bear with me, Mr. Wheel, if that's okay.
Sure. So the court there says, I note that the claimants have not produced for comparison purposes a schedule of their own estimated costs. Although they were under no obligation to do so, a possible inference is that such a schedule would not have supported the criticisms they make of the defendant's schedule. And in my submission, that's a reasonable inference to draw in this case. I mean, you're being told that the costs of DLA, international law firm, an eminent leading counsel, for a very heavy appeal with an enormous amount of factual material to consider, comes to just over $100,000. It's telling that in response to this order requiring this hearing, the appellants haven't produced a schedule which would reveal to the court what a breakdown of their own costs would be. And that's a factor that I invite you to take into account. I don't know, sorry, if you want to give a specific ruling on the procedural points my learned friend's taken, or whether you're happy for me to move on to the quantum issues.
Just briefly, I would like, so I think you've already indicated that your solicitors would be happy to provide an undertaking that a signed statement be provided.
Yes.
So if we could have that, please, in writing to the registry, that would be, we can take care of that point, please. I'm
grateful.
So a signed statement to be provided within 7 days, if that's okay.
I'm sure that's fine. And as I indicated when I made the submission, that signed statement will be subject to some modifications, minor modifications, which I'm about to address you on. So the relevant objections are set out in my learned friend's skeleton argument, and it's probably useful to have that to hand at paragraph 22. You'll recall that the rather lengthy table that my learned friends included. Now, I just want to make a preliminary point, which is when one stands back, my learned friends attacked various specific matters in the schedule. He sought to chip around the edges, but when one stands back, there is no real argument, or there cannot be a sensible argument, but that the respondent has already generated several $100,000 of costs. It's important to bear in mind that the schedule includes incurred as well as estimated costs. the incurred costs, which have already been charged to SBM, already exceed $300,000. So there's absolutely no question about their liability to pay that $300,000 sum. The only question is what's the likely prospective costs. And in my submission, when one looks at this appeal, the nature of it, it's entirely reasonable to expect a further several $100,000. So that's the sort of ballpark we're looking at. And the attempts to chip away around the edges don't really detract from that essential ballpark figure. Now, as I say, I can make a number of concessions in relation to this schedule at the outset, because we now have the actual figures that have been incurred in respect of certain items, whereas when this schedule was prepared, they were only estimated figures. And I can deal with a few points straight away. If you turn to page 11 of my learned friend skeleton argument, there's a criticism made in relation to the time taken or anticipated time for preparing the hearing bundle for this hearing. Now, it was, I acknowledge, a high figure that was given. The reason for that is because an associate had recently left the firm, and the relevant paralegal who would have been tasked with the bundling was on study leave. And so it was anticipated that quite a lot of hours would be needed. In the event, another associate became made available, I'm instructed, and therefore it was possible to prepare the bundle for significantly fewer hours. I understand from my solicitors that the revised figure, which has actually been incurred in preparing the hearing bundle, is $10,720, rather than the $20,900 that was included in the schedule. So it's about $10,000 lower. In respect of dealing with the schedule of costs, I think an anticipated figure of 11,800 was included. I'm told that the actual figure was 8,680. So not far off the estimated figure, but about 3,000 less. And then finally, in respect of the figure for the skeleton argument for this hearing, the anticipated figure was 18,750, but the actual figure came in at 9,950. So taking those 3 points together, I can concede, based on actual figures, that around $23,000 should be deducted from the claimant's schedule, which was around $900,000. But as I emphasized at the start, 20,000 is relatively small beer when compared to a figure of 900,000. So I've made a fair concession in relation to those points, but it doesn't really detract from the fact that we're talking about a figure that's going to run into the high several hundred thousands of dollars. So I'm now going to turn to, I'll deal very briefly with each of the specific criticisms which my learned friend makes at paragraph 22 of his skeleton. So the first point he makes is that there are excessive solicitor hourly rates, and he makes that point by reference to a registrar's direction back in 2017. Now, as you can see from my learned friend's comment about that, the practice direction is indicative hourly legal charges. It's not a hard and fast rule. And there's a few further points to make. The direction now is 5 years old. It's back in 2017. Legal costs have, of course, increased significantly over the last 5 years. Second point is that it is telling that no confirmation has been provided that DLA's hourly rates are not themselves in excess of these indicative charges. And the third point is that these are indicative charges for the run-of-the-mill case. The present case is very far from a run-of-the-mill case. It involves a substantial and complex fraud involving litigants who have proven obstructive. And in my submission, when those matters are taken into account, it is entirely reasonable for SBM to be engaging a firm like Denton's, and indeed for Mr. Mehta to be engaging a firm like DLA. And what comes with a large firm like that, with a complex case like this, is that the hourly rates are in excess of the indicative rates. So that deals, I think, with the first point. Oh, I think there may be a point as well that senior associates rather than associates have been used. As I've indicated, that the relevant associate in fact left Denton's. I think that was on the 1st of September. Another associate has been made available, but her hourly rate is $685. So it's a slight reduction, but it's not going to make much difference. So that's all I wanted to say about the first objection. Sorry, I've dealt with the second one as well, absence of associate time. In relation to the costs of the order dated 9th of August, my learned friend says that the figure of 137,000 shouldn't be included for today's purposes because we've made a separate application in relation to that figure. In my submission, that's not a fair objection. If you order the 137,850 to be included today, then of course we're not going to pursue it subsequently. We fully accept we can't double count. So if it's included, we will simply not pursue that part of the application that's outstanding before the Court of Appeal. As to whether it should be included in principle, well, in my submission, of course it could, because that figure relates to the appellant's application for permission to appeal. So it is part and parcel of this appeal. And in the event that the appeal is ultimately dismissed, those costs, of course, will form part of that and will form part of the order that will be made in my client's favour should it succeed. So there's no reason at all why that 137,000 should not be included at the present purposes. The next criticism that's made is excessive solicitor costs for the preparation of the schedule. And in particular, I think the point my learned friend makes is that a paralegal ought to have been tasked with the exercise of estimating future costs. Well, in my submission, that is simply not paralegal work. A paralegal does not have the experience to project going forward what likely solicitors' costs are going to be for various stages in an appeal. That is a matter that has to be conducted by a solicitor. And on that basis, a large part of my learned friend's objection falls away. In relation to the excessive costs for the skeleton argument for this hearing, I've already dealt with that. The reason it was a higher projection was the absence of an associate. As it happens, the costs have come in substantially less than what was anticipated. The next point is in relation to the preparation of the hearing bundle. Well, again, I've made a concession in relation to that. The total cost, in fact, came in at about half of the projected costs, about 10,000 odd. The next objection, we're now on page 13, is that the cost of the additional conditions application shouldn't be included in appeal costs. In my submission, that's wrong. That application flows directly from the appellant's appeal. Were it not for that appeal, that application would not have been issued, and therefore it effectively stands or falls with the ultimate determination on the appeal, and is properly included as part of the overall appeal cost.
Mr. Whelan, if I can just, I just have a minor question on this point.
Yes.
So the additional conditions application, as I understand it, the respondent has made this application seeking the addition of two conditions, I believe. One is for the payment of costs. I believe that cost order has already been made at some point. And
Yes.
the additional condition is for the payment of the judgment sum.
Yes.
In the amount of around 21 million US dollars.
Correct.
In the event that I make my order for an amount that the appellant does not eventually pay, what would happen to in your view, what would happen to this additional conditions application? It would fall away, isn't it?
Well, In relation to the $174,000, if that's part and parcel of these costs, that application would certainly fall away. The additional condition in relation to the payment of the judgment sum would still be live. But of course, if you were to include the costs of the application within these costs, the Court of Appeal would take that into account as and when it hears that application. But the very short, simple point is that our application for those additional conditions flows directly from the appellant's appeal. Were it not for the appellant's appeal, that application would never have been made, and therefore it's appropriate for it to form part of the overall costs arising out of the appeal that the appellants have pursued. The next complaints, we're now at the bottom of page 13, is that they say excessive costs arise in relation to the respondent's notice. Well, in my submission, these objections miss the point. Now, a respondent's notice is not a document which can be viewed in a vacuum. It's not simply filling in a form. It requires an enormous amount of work to consider all of the underlying factual material that was before the trial judge, because at its heart, this appeal is essentially an appeal on the facts. And there were thousands and thousands of relevant documents that were before the court that are going to have to be reviewed in the context of any respondent's notice. And there's going to need to be conferences with counsel, conferences with the clients, etc. And advice is going to need to be given in relation to it. So it's a vastly more complex and involved task than this objection suggests, which, as I say, it indicates it's nothing more than filling in a form. The other point that's made about the respondent's notice is that it's a hypothetical exercise, because as yet no respondent's notice has in fact been issued. And you may have seen from the procedural background that we applied for an extension of time because we didn't want to incur these significant costs unless and until we knew that permission to appeal was going to be granted. And so, yes, it is the case that the respondent's notice is still hanging, but I can tell the court that it is very likely that a respondent's notice and or a cross appeal is going to be issued, because there's an enormous amount of factual material that we say supports the judge's conclusions, even though it wasn't expressly referred to in the judgment. And so my submission is it is entirely reasonable to proceed on the basis, A, that there will be a respondent's notice, and B, that that respondent's notice is going to involve a very substantial amount of work. I think my learned friend makes, frankly, a bad point about us having deliberately waited for the deadline for the respondent's notice to pass. He makes that point at page 14. I just don't understand that point, frankly. We filed an application for an extension of time before the deadline passed. I mean, I can take you to the application notice. It's at ZZP2. If you look at the part C of that box, you'll see this application was originally filed by the respondent on the 25th of August by way of draft order, etc., etc. So that was within time. What I think then happened was that the court said that the wrong form had been used, and so all that happened was that the extension of time application was made using a different form. But there really is no basis for my learned friend's suggestion that the deadline was deliberately allowed to pass before we took the steps that we did. So for the reasons I've addressed you on, those figures are high, but the respondent's notice is a very substantial exercise, and in my submission, those figures are reasonable. The next item, which appears on page 15, concerns the costs for the appeal skeleton. Again, I think my learned friend invites you to treat that document as if it were in a vacuum, but very substantial time is going to be needed to review the underlying material is referred to in an appeal skeleton. And again, there's going to need to be conferences with counsel and with the clients. And so my submission for a substantial fact-heavy appeal that's likely to last 3 days rather than 2 days, in light of the respondent's notice that we say is likely to be submitted, these figures are reasonable. The next point at top of page 16 is a complaint in relation to the hearing itself. I think part of the complaint is the suggestion that the time estimate for the appeal is 2 days. In relation to that time estimate, that was only given on the basis that the appeal would be as it is now. As I've said, it's likely we're going to need a respondent's notice and or a cross appeal. So you should be proceeding in my submission on the basis that the time estimate is more likely to be 3 days rather than 2 days for a fact-heavy appeal. And in my submission, this number of hours, when one takes into account the very heavy preparation work that's going to be needed, and the consultations with clients and counsel, and the reviewing and marshalling of all the material, this figure of 80 hours is entirely reasonable. Moving on to top of page 17, post-hearing cost submissions. Well, as you'll appreciate, detailed submissions on costs is a very, very heavy and time-consuming exercise. It's going to be necessary to review time entries spanning some 18 months, and that's an exercise that will have to be conducted by solicitors with day-to-day involvement in the case. It's not going to be possible for a paralegal to review and verify certain time entries. So that is going to be a very time-intensive exercise, and in my submission, 65 hours is realistic. In relation to counsel's costs, which is the next item, SBM plans to maintain its existing legal team, which it's had for many months, consisting of 1 leading counsel and 2 junior counsel. The defendants, for their part, are retaining leading counsel and junior counsel. So in my submission, the respondent's legal team is entirely proportionate to the issues that need to be determined on the appeal. I think what's said in particular is that the respondent has failed to provide any evidence in support of the fee estimates which counsel's clerks have provided. I'm not entirely clear what evidence they're expecting, but in my submission, a fee estimate from counsel's clerks really ought to be sufficient for these purposes. And in the context of a heavy 3-day appeal, which is going to need very substantial preparation, counsel's costs are entirely reasonable for a leading counsel and 2 juniors. And then the final point that's made, I think at page 18, is in relation to transcription fees. This is a particularly unattractive point for my learned friend to make. It's suggested that the appellants would agree to bear 50% of the cost of the transcription. Well, I can tell the court that to date, the appellants have been unwilling to share any costs of the transcription in these proceedings so far. And if this was a genuine offer, why would the appellants resist paying transcription fees by way of security? If they're true to their word and they are going to stump up the 50% of these costs, then why not include it in the provision that you make for security today? What we know will happen is that if we proceed on the basis that they can simply be trusted to pay 50% of the costs, they'll allege that they can't afford to, and it will be the appellants once again who are left to pay the entirety of that 11,000. So those are very briefly our responses to the specific objections raised by my learned friend. He makes a further general objection, I think, at paragraph 23, which is that the respondent has failed to provide invoices. Well, given that the vast majority of the schedule relates to estimated costs rather than past costs, it stands to reason that there can be no invoices in relation to that element. But as I said, I can confirm, and my solicitors will provide a signed statement which confirms that over $300,000 has in fact been incurred, and the client is in fact liable to pay that sum insofar as it hasn't already been paid. So overall, I simply repeat what I've said about taking a step back, look at the big picture, look at the nature and complexity of these issues, take into account reasonable contingencies, including respondents' notice, the fact that the appeal is likely to be 3 days rather than 2 days, and in my submission, the estimate that's been provided and the figure of around $600,000 that we seek is entirely within the spectrum of what's reasonable, and the court should therefore order a sum in that figure to be provided. Is there anything specific, Registrar, before I hand over to Mr. Pillai, on which I can assist you with?
There is just one point in regards to the counsel costs.
Yes.
There is a figure that is set out in the appellant's skeleton argument of $45,000 for counsel, which includes travel time and accommodation.
Yes.
Yes. I think Mr. Pillai has made the suggestion that because the appeal hearing will be hosted virtually, there should be significantly less travel costs.
Yes, sorry, I should have addressed you on that point. In fact, the position is that, as I understand it, no determination has been made either way. I don't know where Mr. Pillai gets the suggestion that it has been ordered that the appeal will take place by way of a remote hearing. I apologise if I've overlooked it. If I have, then of course the cost schedule should be reduced. But as I understand it, as things stand, it's an open question as to whether or not it's going to be in person or remote, and on that basis we've built in the additional costs that we have.
I can just take care of this point right now. It will be virtual.
Okay.
So if we could have a revised figure on that, Mr. Ria, that would be. I'm
grateful. I mean, for the sake of argument, you could probably take off around $20,000. That may not be a precise figure, but that's a stab at an estimate.
Unless there's anything further you'd like to address me on, Mr. Ria, we can move on to Mr. Pillai.
I'll deal with any other points in reply. I'm grateful.
Mr. Pillai.
Thank you, Madam Registrar. I apologise. I can't see either of you, so I had assumed everyone had their cameras off. But I understand you're both on, so I'm just going to sort of speak at my image, which is always unpleasant. Madam Registrar, I'm just going to make some introductory points and then move on to the evidence and the points that Mr. Wheel has made. I think we need to put this appeal into its context. At the moment, on everything that you have before you, this is a 2-day appeal, and it has already been fought by SBM on all the fronts that are being advanced. And the court knows this, and Madam Registrar, you indicated your familiarity with it, because it was fought in front of Justice Lord Glennie when he addressed both the set-aside and the permission to appeal application at an oral hearing, precisely in order for him to hear argument on these points. And central to both the tests for a set-aside and for permission to appeal is the question as to whether there's a real prospect of success. And so therefore the merits of this are not coming new to any of the parties in preparing this. And then secondly, you heard about this being an appeal on all of the facts and so on and so forth. That again is a gross exaggeration, because the focus of this, as is reflected in the Chief Justice's order, perhaps, Madam Registrar, if you could turn that up at ZZM 105. There in the Chief Justice's reasons, at page 107, if you have it, can you see at paragraph 4, the point is made about the judge holding that out of the 6 representations, 4 were non-fraudulent and only 2 were fraudulent. That's really going to be the focus of any appeal. It's going to be the context in which these 6 advances were dealt with, and the basis on which the judge we say wrongly, found that 2 of them were fraudulent when the previous 4 had not been fraudulent. So I think all of this does have to be understood, and the costs and the nature of this appeal on the grounds for which permission has been given, of course, the factual context is actually relatively restricted. Madam Registrar, then the next point is that there is no dispute that Mr. Mehta is impecunious, and he's disclosed all of his assets in relation to the worldwide freezing order, and that's been done on affidavit. And now that you know about the sideline contempt proceedings, where Mr. Mehta, of course, has applied to have those set aside. So there's no issue as to the fact of his impecuniosity. There is no issue as to the circumstances in which that all came about.
I'm sorry, I do need to jump in here. I do need to jump in here because
I don't think that that's appropriate. I'm sure that Mr. Wheel knows well the procedure, that he'll have a chance to reply.
No, this is not a reply point, Madam Registrar. You made clear at the outset of the hearing that you were against the appellants in relation to impecuniosity. Contrary to what my learned friend says, that would have been and is a very hotly contested issue. If you are to permit my learned friend to make arguments, despite your determination that you were against them on that, then I will need a full opportunity to take you through why you should reject Mr. Mehta's evidence in relation to his stifling. But in the first instance, I invite you simply to stand by your original determination, which is that you are against the defendants on this, and therefore Mr. Pillai should not be allowed to address you on it further.
Madam Registrar, if, and I don't think I had understood it this way, if you had been suggesting that you were going to make findings on stifling without hearing oral argument on it, and that would have been rather surprising. But in any event, the question of stifling is central to the question of what amount the court will order by way of security for costs. So either way, it's not something that is closed out. But I would have been very surprised if that had been the effect, Madam Registrar, of what you're saying. And in any event, Mr. Wheel will have his chance to respond in the usual way. So, as I say, the legal test, which is what I was going to go on to, is at the Pesante authority, which is at ZZS 51. And I wonder if you could turn that up, please. And we go to paragraph 88, which my learned friend touched on.
Bear with me, Mr. Pillai.
I'm scrolling down myself. I'm sorry, I'll find the page. Page, I think it's page 75, ZZS, page 75, madam.
Yeah.
And you looked at the first point, so paragraph 88, and this I think is the only authority dealing with how you deal with the appropriate quantum, and it refers to the White Book. And we have point 1 there is one that none of this is in dispute. I cited this in my skeleton argument, but about that what you will do, madam, is approach this on a robust basis with a broad brush, and then you will possibly second consider whether you how you apply an overall percentage discount. Third, in deciding the amount of security to award, you may take into account the balance of prejudice, and this is the point that will look an applicant would suffer. Well, so there the applicant who's getting security would suffer if too little is awarded, and of course that's relevant. But what I say in relation to that is what's not Mr. Mehta's position is he's not doing what parties sometimes do, which is to say, look, this is a cakeist argument, if I may, which is that, well, heads I win, tails you lose. I'm not going to pay any security. I'm only going to pay my lawyers. Because when we come to the evidence, you'll see that he is offering and he has tried to raise what he can, and he deals with that. And I think you have that on board. So, Madam Registrar, point 4 deals with the English Commercial Court, so isn't relevant. And then point 5, in determining the amount of security, the court must take into account the amount that the respondent is likely to be able to raise. The court should not normally make continuation of their claim dependent upon a condition which it is impossible for them to fulfill. So, Madam, that, of course, is directly relevant here. And if you look then at the evidence, and I think you've already had a chance to look at it, it's a ZZQ 78. And it's a short statement. And there, I think you've seen paragraph 5, Madam Registrar, Mr. Mehta explains the costs that he has incurred and that are estimated. And I've heard what my learned friend says about it. This is given to him on the basis, this is evidence before the court. The estimates are those provided to him by DLA. I have no reason to look behind it, and nor I say, do you, Madam Registrar. They're much lower, but it isn't some sort of artificial lowering. It's what's appropriate and proportionate for an appeal, as I say, where the ground has been run already. And then Mr. Mehta goes on at paragraph 7 to explain the context, and it won't come as a surprise, Madam Registrar, that given that he's impecunious, he is suffering from the difficulties of both the difficulty of finding someone to approach and the embarrassment of that. And he explains then at paragraph 9 onwards the various approaches that he has made. Madam, as I can't see you, can I take it that you have reached that section?
Yes, I'm with you. I'm with you.
I'm grateful. I think you may have looked at this already, but paragraph 9 deals with Mr. Kankani, and you see there at the very bottom of that paragraph that Mr. Kankani eventually agreed to support me financially to the extent of a maximum of 50 to 60 towards the payment of the security. So there he is making out the point that I've explained, Madam Registrar, that he is trying to get security. So it's not just his own legal fees. Then he goes on, Mr. Mehta, to explain about the limited extra support and comments from others. And finally, he explains at paragraph 16 that he may be in a position to procure funding up to a maximum of 60, 65,000. But if it was to order above that level, he'd be left with no option but to drop the appeal, and so on and so forth. And at the core of this, of course, is an appeal to overturn a finding of fraud against Mr. Mehta. And if he succeeds on that, then all of what has happened below falls away, and his name and the allegations of dishonesty fall away. And Madam Registrar, you will have seen throughout this litigation that equality of arms through legal representation has been crucial. He would not have got permission to appeal without legal representation. That's clear. And that's why, and he's had funding only sporadically throughout this process, but that's why it's so important that what the court does here should not be in an amount that makes it impossible for the appeal to continue. And the touchstone here is, as the Chief Justice has said, that there is a reasonable prospect of success on an appeal, and that there should be a presumption of innocence. And you've heard nothing from Mr. Wheel that goes against what I cautioned against in my skeleton argument, that there would only be mud thrown. And that's what happens. But unfortunately, one further aspect of that is the nature of the approach to this application for security. Because what's plainly happening here is, firstly, you've heard me about the form of the spreadsheet, but you've got a spreadsheet for 900,000, which is hoping that they'll still get a really very high number. And you heard bandied about by Mr. Wheel, oh, well, there is definitely 300,000 already incurred. But as I say, that's given to you orally by counsel, which is not the right way through. And if we could then look, Madam Registrar, at the schedule, and perhaps we could go through this again, if you have my skeleton argument to hand, as I think you went through with Mr. Wheel, the points beginning at page 8 of the skeleton argument. What's telling in my submission is that already where you've had two discounts applied, as it were, you had a discount applied in relation to the costs of preparing the skeleton argument. And that was effectively a 50% discount. So 9,000 odd, where they had claimed 18,000. The same goes for the solicitor costs of preparing the hearing bundle. You've got a sort of 50% discount. So that, we say, is demonstrative of the approach that's been taken. It's one thing to say, you know, we want to make sure we cover it, but when you double the costs, the net outcome of doubling costs is to inflate a spreadsheet that is then used as the basis for the court's exercise. And what's plainly hoped at here is that worst case is a judgment of Solomon, somewhere to reach halfway between the two different sides, and we said that would be inappropriate. So, Madam Registrar, with those comments in mind, I'll take it quickly because you're familiar with the point. In relation to the excessive solicitor hourly rates, we say the guidelines should be followed. This court has not updated the guidelines or seen it appropriate to do so. So we say that those are a proper starting point for this court, and that by those measures, the hourly rates against which costs are claimed are significantly excessive. In relation to the associate time, we say that that's a matter for resourcing properly, and it's not something for which the party that loses a case can be penalised. If there's a resourcing issue and the wrong associate and the wrong fee earner level is being applied, well, that's a problem for the law firm and SBM, but it's not something that should be visited upon the other side in the event of an adverse costs order. In relation to the third entry then on page 9, Madam Registrar, the costs payable to the consent order, we simply don't see how that can possibly fall into this category when they have got this other hair running. It's entirely improper both on this and in relation to that the other entry about the costs of the other application. They have chosen to bring two conditions, an application for two conditions to be added in circumstances where the Chief Justice had a full context of the hearing to date before him, and he decided on the single narrow condition to be added, which was cost of the appeal. He plainly could have applied other conditions if he thought it appropriate, but he didn't. Now they have chosen to bring a separate application, which has been run on their separate track, and that's where it should stay. And what this court should not do is, again, inflate and add in and lump on top the cost of the appeal, something here that we say is a sideshow and should never have been run. Because otherwise what that serves to do is to inflate artificially and go beyond plainly what the Chief Justice had in mind as being the costs of the appeal. In relation to then security for costs and the preparation, we've had the discount, which shows this was about, I think, 3,000 extra. In relation to the next one, you see that they doubled their bill, and Mr. Wheel has now conceded a half the amount, and that, we say, just goes to show that we were right to point these criticisms out. The same applies to the next head, Madam Registrar, the solicitor costs of preparing a hearing bundle, again doubled in their estimate and then had to be conceded. Madam Registrar, then at page 13 of the skeleton argument comes in the entry about their estimated costs, and there are all sorts of promises about, oh, well, we'd take this out, we wouldn't deal with it. It's simply entirely improper for it to be considered in this schedule at this hearing at all, because, as I've said, it's a separate application, and one we say that should fail, but also if you look at why it's here, why it's in here is to give them a higher number in their attempt to get you a very inflated figure and therefore stifle the prospects of an appeal. going ahead. Madam Registrar, in relation then to the next head, the excessive solicitor costs. Now, they're claiming here 80 hours in total. That's 8 full days, 10-hour days. And we say that, firstly, it is hypothetical because they haven't done it yet, and they could easily have done so. The time has elapsed, they've had to apply for an extension, and that again has to be dealt with separately. But even assuming a respondent's notice is going to be filed, and we heard what Mr. Wheel said, that he thinks it's likely to be filed, there's no way that the solicitors need to spend 8 full days on it, because there's, as I've already pointed out at the top of my submissions, there's nothing really new under the sun here. SBM knows the scope of the appeal. The idea that they're going to have to spend 8 days worth of solicitor time, and remember, this is likely to be heavily dealt with by counsel in any event. The idea that the solicitors are going to spend 8 days on this, we say it is nonsensical. And that's 8 individual days. However you split it, the 80 hours and the 60-odd thousand, the 59,100, we say is grossly excessive. And it's of a piece with what you've already seen. And the same headline submission applies in relation to the next head, Madam Registrar, which is on my page 15, about the solicitor costs of preparing the appeal skeleton. Again, that's 73 hours, 7 days of a solicitor's time on heavy days. They're not drafting this. It can only be a 25-page document. Everybody knows the substance of the arguments already. While we accept, of course, that some time is needed to refresh and update, this again, to give you another 50,000 sum, is grossly inflated, we say. And the same point applies to the alleged solicitor costs for preparing the hearing. This is an appeal to be run through the 3 counsel that Mr. Wheel has referred to, 80 hours, 8 days between them of solicitor preparation for a 2-day appeal. Even if it's a 3-day appeal, one can't see possibly what they're going to be doing to be gainfully employed for that. 57,100. Again, it's another convenient 50-odd thousand lump. It's the third of such lumps, which he says completely unrealistic. And again, the next point is in relation to solicitor costs for hearing. We say it is a 2-day appeal, and as at today, we don't see why it would be 3 days, even if there's going to be a respondent's notice. But it's hypothetical, so I can't sensibly comment on it. But then nor can with respect the court, because there's nothing to assess this apparently expanded profile against. And then moving on to page 17. The 47,000, we say 65 hours is again a gross overestimate on submissions on costs. It's over 6 days on cost submissions, and an irony that they would, at the point about arguing about costs, still be trying to inflate and spend too much time on it. And in relation to counsel costs, we've seen some discount. I think the only point that's made is that it would have been easy to provide some evidence of it through providing fee notes or fee estimates through counsel's clerks. Now, bear in mind, the criticism is made before any promise of a signed or compliant statement. But we say it's easy to provide. If you've got a number here, how did you get there? And they're asking for it, so it's incumbent on them to give the court comfort in relation to that. And finally, on transcription fees, the offer, as I understand it, would be there. There's just been no discussion about it, so there's no basis for putting the full sum in. So, Madam Registrar, those are my submissions, both in terms of the context in which this costs estimate have to be put in, but also the sums claimed. And then I remind you of those 2 points. Firstly, the touchstone, the crucible through which this needs to be assessed, is what the Chief Justice has said in giving permission to appeal about the presumption of innocence. And then when you're approaching this, the legal approach from the Pisante case, which is that costs should not be set an amount that would prevent the appeal from going ahead. Now, you have evidence about that. You have evidence about efforts made to try and raise security and the level of that. And we say for those reasons that security should be set at $65,000. Madam Registrar, unless I can assist you further, if you have any questions, those were my submissions.
Thank you very much, Mr. Pillai. Mr. Reid?
Just a few points in reply, if I may. The first point my learned friend made was that essentially we've already had a dress rehearsal for the appeal through the permission to appeal application. That's not correct. As you know, Registrar, a permission to appeal application generally focuses very heavily on what the test for permission to appeal is and whether or not it's been satisfied. We're now a stage more advanced than that, and we're going to have to engage in detail with the substantive evidence. So it is a completely different proposition. The second point my learned friend made was that there's no dispute that Mr. Mehta is impecunious. As I indicated at the time, I really struggle to see how my learned friend can make that argument with a straight face, frankly. We've made clear in our skeleton and elsewhere that we hotly dispute the suggestion that Mr. Mehta is impecunious. And I do just make 4 points very briefly as to why you should have no hesitation at all in rejecting the argument that Mr. Mehta can only afford to pay the 65,000 odd that he claims. The first point is that Mr. Mehta's 10th witness statement was filed by way of ambush at the same time as my learned friend's skeleton argument. It was deliberately held back until then, knowing that we wouldn't be able to respond to it because we would already have filed our skeleton argument. Now, Mr. Mehta has known about this order since August. He could have put forward evidence if he wanted the court to consider it long ago, but he's chosen to delay it until a few days ago. So for that reason alone, because SBM hasn't had a fair opportunity to consider and respond to it, you should reject or not even consider his evidence. The second point is that if you're minded to take it into account at all, which I say you shouldn't, it is obviously deficient as evidence of impecuniosity. And in that context, I invite you to look, please, at our skeleton argument at paragraph 16.1. And there we set out some of the guidelines.
Bear with me, Mr. Wheeler. I just need to.
I'm sorry.
Which paragraph?
So it's the highlighted text beneath 16.1 that makes clear that where you're trying to rely on your impecuniosity as a respondent to a security for costs application, the onus is on you to put forward proper and sufficient evidence, and you're required to give full and frank disclosure. And there's some further guidance which I'd like to refer to very briefly in relation to a judgment of Sir Richard Field, as it happens, in the Michael Wilson case. And you'll see that at tab 7 of ZZT, it's ZZT 71. And I invite your attention to paragraph 29.4 of that judgment. It's perhaps worth starting at 29, which is ZZT 79. This is in an analogous context of debarring a party from participating in the litigation insofar as they fail to pay a cost order. But in my submission, the principles on this issue are analogous. And if you scroll down to subparagraph 4, what Sir Richard Field says there is that a submission by the party in default that he lacks the means to pay should be supported by detailed, cogent, and proper evidence, which gives full and frank disclosure of the witness's financial position, including his or her prospects of raising the necessary funds. And then if you look at subparagraph 5, where the defaulting party appears to have no or markedly insufficient assets and has not adduced proper and sufficient evidence of impecuniosity, the court ought generally to require payment of the costs order as the price for being allowed to continue to contest the proceedings, unless there are strong reasons for not doing so. So the question you have to ask is, has Mr. Mehta provided cogent and detailed evidence and given full and frank disclosure of his financial resources? And in my submission, he plainly has done nothing of the sort. If you look, please, at his evidence at ZZQ 78, the relevant passage begins at paragraph 6 on page 79. All that section amounts to, and it carries on at paragraph 9, is a few bare assertions as to various people who he is alleged to have contacted to provide him with money. There are no documents exhibited showing any relevant correspondence and no documents in evidence as to the respective financial positions of these supposed backers. But more importantly, Mr. Mehta has provided no proper evidence to establish his own impecuniosity and that of RENISH. Now, it's important that you recall that there is no dispute that RENISH has received several $1 million from the facility agreements. You said you're familiar with the background. You'll recall that one of the features of this case is that money came into the NBK account destined for Prime, only then to bounce back to RENISH. And there are several $1 million that we know, it's not disputed, ended up in RENISH's bank account. Where is the full and frank disclosure to show where that money has gone, such that RENISH is unable to make payment of a much lesser sum? Now, the only evidence that my learned friend relied on in support of his submission as to Mr. Mehta's impecuniosity is his recent statement. But insofar as my learned friend implicitly made reference to previous evidence, which I don't accept, but I'll give him the benefit of the doubt, that previous evidence was also wholly inadequate. So Mr. Mehta has variously put in evidence in the past which makes assertions about his bank balance being zero for various bank accounts and about various properties of his having been the subject of enforcement proceedings by banks. But crucially, he has never at any stage exhibited underlying documents that evidence his assertions. He's produced no underlying bank statements. He says he's unable to get them, but he hasn't produced any evidence of any attempts to get them. And he's produced no underlying documents to show what the status of the various real estate assets that he and RENISH appear to own is. So on its face, the evidence that my learned friend has referred to is utterly woeful insofar as it is evidence of impecuniosity. That's the second point. The third point is that Mr. Mehta would have the court believe that he can only afford to pay $65,000, and yet the fact is he's paying DLA Piper, an eminent leading counsel, to represent him today and at the appeal. So it is striking that on the one hand he says he's got no money, but on the other hand he magically is able to produce enough resources to fund an international law firm and eminent leading counsel. And in my submission, that should give the cause significant pause for thought. And the fourth reason why I submit that you should reject the alleged impecuniosity is that impecuniosity is only normally a reason as to why the court should tailor the level of security down to what the appellants can afford. You see that from my learned friend's skeleton arguments in the extract he cites at paragraph 10. And the relevant passage is right at the bottom of the extract he cited, immediately above the heading that says C application. And what's said in the Pisanti case is the court should not normally make continuation of their claim dependent on a condition which is impossible for them to fulfill. Well, in my submission, this case is very far removed from the normal case, even if the defendants have provided cogent evidence of their impecuniosity, which they haven't, and even if they had produced their evidence in sufficient time for SBM to be able to respond to it, which they haven't, even then the court should reject the impecuniosity. And there are two particular features of this case which I draw to your attention as a reason why the impecuniosity argument should not succeed. The first is that it is undisputed that the defendants already owe the claimant over $30 million by reason of the immediate judgment on the contractual basis. So whatever happens in the appeal, even if the appellants have their best day in court, they will remain indebted to SBM for over $30 million. The best case scenario for the defendants is that they get a cost order in their favour following appeal, but on their own evidence, that cost order is only going to be in the sum of around $100,000. And that's an important point to bear in mind, because what you're doing when setting the level of security now essentially is protecting SBM against the risk of a further shortfall in the recovery of its losses that are being run up as a result of the defendant's conduct. So the first feature is that the defendant's indisputed indebtedness. The second feature, which I know the defendants don't like me referring to, but is their conduct in relation to the worldwide freezing order and the fact that they have been found to the criminal standard by this court to be in contempt. Now, it's all very well to say that they're going to pursue a purge application. That application, Registrar, is a complete red herring, because what it doesn't affect is the fact that the court has found they've committed a deliberate and serious breach of a court order. Nothing that happens in the purge application will detract from that. All it will do is mitigate to some extent the seriousness of the breach that the court has found to have existed, which goes to the question of sanctions. So for those reasons, in my submission, you had no hesitation at all in rejecting impecuniosity. Your initial indication at the outset of the hearing was entirely correct. The focus of your determination should very much be on the schedule and on the appropriate quantum, ignoring what Mr. Mehta says about his alleged indigence. Now, then I'm not going to repeat what I've already said on the schedule. I'm just going to make a few points in reply. I think Mr. Pillai suggested at one stage that you had to take my word for it that that the respondent had already incurred over $300,000 in costs. Well, you don't have to take my word for it. You can see that from the schedule itself. I don't know if you have the schedule to hand. I'm grateful. And you can see from the breakdown of figures at the top that SBM has in fact been billed. It was billed on the 30th of September for a sum in excess of $300,000.
Sorry, which tab are we looking at, Mr. Wade?
This is the, sorry, just have a moment. Yeah, it's ZZL, page 1.
This is the schedule.
Exactly. And if you see the
looking
first
at the Excel
two
sheet
items.
itself. I'm not looking at it from the bundle, I'm looking at the sheet itself. And there are several tabs therein.
Okay, I hope this is the same document that I'm looking at, but on the first page there's a summary. I don't know if you see that.
Okay, got it.
And you see the first two items, they say that the fees have been billed for the period 30th. Yeah, so you don't need to take my word for it. You can see that over $300,000 has already been billed. So in my submission, there's just no argument about that. That $300,000 goes into the pot, subject to any reduction you make, but there's just no argument that that's incurred. The only dispute is what additional sum to that 300,000 should be added by way of prospective costs. And the very short and obvious point to make in relation to that is the appeal hasn't really got going. We haven't had to engage substantively. The hearing is some way off. There's the respondent's notice and all that to consider. Of course, the prospective costs are going to be significantly in excess of the 300,000 that's already incurred. So we're immediately talking about a figure that's in excess of 600,000, and in my submission, significantly higher than that. Then in relation to the specific points that my learned friend makes. I'm not going to repeat what I've already said. Unsurprisingly, my learned friend sought to highlight the fact that I've conceded a 50% discount in relation to two specific items. He didn't mention the third item, where the discount was more like 25%, and so was in around the right ballpark. But in relation to those two items that I've referred to, there were specific circumstances that explain why the figure was higher in anticipated than it turned out to be the case. And that was by reference to the associate that I mentioned, who left the firm with the possibility that it would have to be handed over to a new fee earner. So I've explained the reasons why that figure came in higher than it turned out to be the case. But you can't draw any wider inference in relation to the entirety of the rest of the schedule based on that. And then just one other point, discrete point, I just come back on. I think my learned friend suggested that our skeleton argument was only going to be 25 pages. The fact is, my learned friend's own skeleton argument for the appeal, I think, came in at 45 pages. So we are not dealing here with a normal case. This is a very, very heavy, fact-heavy, complex appeal, which is going to require a huge amount of effort from both solicitors and counsel. And I just invite you to stand back and take a realistic assessment as to what that will result in practice. So unless I can assist you further, that was all I was going to say in reply.
Thank you, Mr. Real. Mr. Pillai, would you like to make short
Yes,
submissions?
very quickly. Madam Registrar, I think what this Mr. Wheel's submissions and the force with which he relays them demonstrate this really boils down to an attempt to smash Mr. Mehta down without any appeal. It's essentially being said he's a fraudster, that's that, what's the point? I've explained really why the permission to appeal and the points made by the Chief Justice militate against that. It's also wrong to suggest that Mr. Mehta has not set out his position on evidence. Can I just ask you to look at ZZQ, not for the detail particularly, though you're welcome to look at that, of course, but the affidavit of Mr. Mehta, ZZQ1, sets out his position on assets. And you're not going to be able to get to the bottom of that, but presumably if there were criticisms further of asset disclosure or breach of the order, that would be pursued further. But Mr. Mehta's position is he's given an affidavit, he's corrected any shortcomings, he's applied to purge contempt, and this is his position and explains his asset position. As to the suggestion that the witness statement was late or an ambush, the cost schedule only came in on the 12th of October. So that's when we first see a £900,000 claim for costs. And then the evidence came in a week later with the skeleton arguments. So there was nothing to fight against, or really any form to refer against, until this spreadsheet was provided on the 12th of October. And so if this comes in a week later, my submission, firstly, that's not late. And secondly, it's plain from what Mr. Wheel did in taking you through it that there's not been any issue in considering it and engaging with it. He makes some criticisms about a lack of underlying documents, but it's plain that these are all conversations that were had in relation to try and drum up funds. So we say that that's the appropriate balanced way in which to look at the evidence. The debarring case is irrelevant, firstly because it's for an unless order, and that isn't the context that you're dealing with at all, Madam Registrar. And secondly, that the criticism there is still only, well, it depends on what evidence you have. And we say you have evidence that sets out the position. Madam Registrar, the only final comment is that when obviously one's dealing with the overall schedule, whatever figure, if you are minded to take a figure as being the costs against which analysis should be given, is that you should then drop that by a significant discount. And we've said 60 to 65% is appropriate. There is, of course, the veggie bar case where it's 50%. We say that would also be appropriate depending on where the court has come. But the primary submission, as I set out, is for an order that reflects the amount that we say Mr. Mehta says he can raise. unless I can assist you further, Madam Registrar, those are my points.
Thank you, Mr. Pillai. So I will reserve my decision, and the parties should hear back on directions specifically relating to the headline figure provided by the respondents. To give a further indication, I've not changed my mind. I reject the appellant's impecuniosity argument. I do believe there is a further amount that can be paid by Mr. Mehta in costs. I do not wish to have or subject SBM to further shortfalls. At the same time, I do not wish to stifle the appeal. So there might be some form of balancing that I will have to do. And in doing that, I do want to discuss the figures that are set out in the schedule. So, Mr. Wheel, what I would like to come into the court is basically I would like the figures to be in accordance with the registrar's direction 1 of 2017. I understand that it is quite old. It is 5 years old, to be specific, but we did undertake an exercise a year ago and found that the hours had not really changed, which is surprising, but which is the reason why we haven't made any amendments to the registrar's direction. And in this court, we do tend to, while it is not a hard and fast rule that we should be sticking to the indicative hourly rates as they are indicative, in the interest of not stifling the appeal, I would like to bring those rates down in a sense, and would like the rates provided in the costs brought down to the rates that are set out in the registrar's direction.
Could I just, well, first of all, just one point of clarification in light of what you said, and then a suggestion as to how we can assist you. In relation to the point of clarification is this: as I understand it, you've rejected out of hand the stifling argument, or you've rejected all of the evidence on impecuniosity. On that basis, it must follow that the stifling of the appeal falls away because you've got no reliable evidence that Mr. Mehta is unable to meet any sum, in which case the stifling issue essentially falls away, and the focus is purely on the quantum in the schedule. So I just thought I'd clarify that. In relation to what you've just said, can I suggest this, that my solicitors file an amended schedule, which includes at least, perhaps in addition to, if not to replace the existing figures, what those figures would amount to if the guideline rates were applied, so you can see for comparison purposes, and also to update the schedule by reference to the 3 concessions that I've made. So then you will have a definitive document that says this is what the numbers look like if the guideline rates apply, including the concessions I've made, but you will also have alongside that the actual figures so that you can take those into account as well. Would that be of assistance?
That would be an assistance, but I think Mr. Pillai would like to say something.
Madam Registrar, only that Mr. Wheel's rather garbled opening, I think, trying to box the court and perhaps my client into something. You indicated that you're going to reserve your decision and no doubt will provide the reasons, and also indicated that you don't wish to stifle the appeal. So in those circumstances, I mean, as I understand it, we'll see a further schedule from Mr. Wheel's side, and then the court will hand down its decision on security with reasons. But I don't understand that there's been a rejection of evidence one way or another. If the court wishes to clarify that now, so be it, or in a judgment. But I'm not quite sure where Mr. Wheel was going with that. So I just wanted to get a clarification.
Mr. Wheel?
It's a very simple point. I think you said expressly, Registrar, that you hadn't changed your original view and you rejected Mr. Mehta's evidence of impecuniosity. It follows from the rejection of the evidence of impecuniosity that stifling the appeal is simply not an issue that arises for consideration because there is no relevant evidence that an appeal will be stifled. That's the short point.
I don't think by me undergoing this exercise, there would be a stifling of the appeal, if that clarifies the matter. I do think my initial view remains the same, that I do think these costs are excessive and I do want to bring them down, but I do not want to prevent Mr. Mehta from having the opportunity to attempt to raise funds on whichever way he deems fit, whether it's by borrowing from his friends or finding other means. I think basically I do want to find middle ground between both sides. And the only way I can see I can do that is basically trying to bring down these prospective costs, because I do, from experience, I can tell you that these are excessive. And I am going to attempt to come to a figure after obviously seeing a revised schedule from your side, Mr. Wheel, and then possibly providing a percentage reduction on that amount. So that's where I'm leaning right now, having heard you, Mr. Wheel, and Mr. Pillai, and I will have to see a figure come down, but I do not wish to stifle the appeal in the sense that I do not want to prevent Mr. Mehta from having the opportunity to pay an amount that he says he may not be able to pay, but I would attempt, I would like to encourage him to find a way to make payment without, because I don't wish to subject SVM to further shortfall. So that's where I am right now. And a revised schedule, I think, would help a lot in helping me carry out this exercise.
That's understood. We'll get that to you as soon as possible.
All right, thank you very much. So can I expect, first of all, the signed and sealed statement of costs, Mr. Wheel, within 7 days, and the revised schedule within another 7 days?
I'm confident that's fine. I'm afraid, as you may have seen on the news, WhatsApp is down, so I can't get instantaneous instructions on that. Without overcommitting my solicitors, I'm sure they will endeavour to get things to you sooner than that if they possibly can. But that timetable sounds realistic.
Mr. Pillai, do you think you would benefit from the opportunity to respond to the schedule?
I would be grateful for time to respond, or the opportunity. Yes, please.
All right.
Madam Registrar, and everything that you have said is all understood. So, it will be short and to the point.
Just on that point, so there's no confusion as to what this revised schedule is doing, because we clearly want to avoid a repeat of the hearing we've just had. All the revised schedule is going to do is to correct the 3 points that I've addressed you on, and it is going to substitute figures for each of the solicitor fee earners for the guideline daily rates. So I really don't see why there should be any need for Mr. Pillai to come back on those, and all that is likely to do is to generate a further round of submissions and correspondence, largely repeating what you've already heard. So given that clarification I've just provided as to the very narrow scope of the revised schedule, in my submission, you've heard what both parties have to say, and you really do have all the material you need to make a determination.
Mr. Pillai?
Madam Registrar, I just don't understand why Mr. Wheel persists in trying to shut out argument against his client. All this would be, as I understand it, would be commenting on a narrow basis on the schedule, whether that's arithmetic or any clarification or correction, and just checking to assist the court. I don't think there would be any issue. I think it would be a short submission in response, if any. And I think the court would be assisted by it, and then we could draw a line under it. So I would ask, the court offered it, and I would ask for that opportunity, please.
As long as their submissions are limited to the changes made in the schedule, I'm minded to allow it.
I'm grateful.
All heard and understood, madam.
Thank you very much, Mr. Whelan, Mr. Pillai. Thank you very much. Have a nice day.
Good afternoon.